Okay, gentlemen, I have questions for you here, and whoever wants to answer first, please feel free to do so. Both of you can weigh in and even discuss amongst the two of you if you choose to. But here's the first question. If I have a pending appeal, what options would you recommend, considering the decision which holds that the appointment of PTAB judges is unconstitutional?
So this is Peter here. I'll jump in and take that one. My recommendation at this point would be, if your client is willing, to go ahead and try to file something with the Federal Circuit, even if you didn't happen to raise the issue in an opening brief, given that it appears that the issue of waiver in particular is very undecided at the moment, and there will probably be a further word on that from the Federal Circuit. And I'd also note that the issue of waiver, particularly, the law is that waiver is case specific. So it may be that you have particular circumstances in your case that would allow you to distinguish your case from the few cases where the Federal Circuit has found waiver, in particular the custom media and the Sanofi cases.
Okay, James, you have anything you'd like to add about that?
Nope, I don't. I agree with what Peter said. And for now, you want to raise it, no matter how late it is, I guess, and because the issues are still being worked out, and it may be, maybe several months before we have more feedback on it.
Let's go to a first question then. Gentlemen, with the recent developments, how should in-house counsel change their IPR strategies? I'd like to tackle that one.
I think, this is James. I think for the topic that I presented on, I think that if your prior art, if you want to rely on a prior art defense in district court litigation, and the system, you want to rely on a notar-used theory, notar-used prior art theory, where based on a real-world system, and that real-world system is described in patents or printed publications, you'll want to have at least some evidence that you bring before the district court that you could not have brought as a printed publication in the PTAB, so that you can make an argument that your theory in district court is at least substantially different from the one that either was presented or could have been presented in the IPR.
Peter, anything you'd like to add on that?
Yes, I'd also add, in view of the, I guess I'll call it, constitutional uncertainty regarding various aspects of IPRs, it may make sense for an in-house counsel to be more open than maybe he or she otherwise would be to creative arguments that your outside counsel brings to you. It may add a little cost to a particular brief to research and develop and then make these arguments. But particularly if you own patents and you are trying to defend them in a parties review, and particularly if it's a very valuable patent for your company, it makes sense to do whatever you can to defend that patent. And I think these, again, I'll call them more creative constitutional and or procedural arguments, while they might have a relatively low chance of success, the upside is large. So it may make sense to be more open to maybe spending a little extra money on those types of arguments.